Hey everybody, we will wait about another 30 seconds before we get started here just to let everybody else get in and make sure that their technology is working correctly. So we will get going here in just a moment. All right, let's go ahead and get going. Hello, welcome everyone. Thanks for spending your lunch hour with me. Thank you for joining us today. My name is Kiki Dilly, and I am one of the shareholders here with Altitude Community Law, and I also run our debt recovery department. So I am happy to talk all day long about collections, although instead I will only talk for an hour. So if anybody has any questions that I can't answer during the session, please feel free to call me or send me an email or call me. And my contact information is listed at the end of the webinar. So we will certainly get you that information, and I will be happy to answer any questions that I can. So on your screen, you should primarily be seeing the PowerPoint presentation, and you should additionally be seeing a small box on the left-hand side of the screen with the presenter. That's me. And on the right side of the menu, you'll see a private chat icon. Please use that icon to type in your questions throughout the presentation. I'll do my best to answer questions as they pop up, although I want to also make sure that we get through all of the material. So I may hold off answering some questions until the end. We'll just kind of see how it's going as we proceed. If you have any audio or video issues during the presentation, please click the no audio or video button below the PowerPoint on your screen and follow the instructions there. One CMCA credit will be automatically generated and emailed to you within 48 hours after the webinar, assuming you attended the entire program. These credits are not transferable. As a reminder, this presentation will be recorded and added to the Altitude YouTube channel within a couple of days. Feel free to refer back to that. Again, it does have my contact information right there at the end. So if you don't write it down before we close down or anything like that, you can jump back on there and get it. Lastly, there will be a survey that will pop up at the end of the webinar, and we really appreciate any feedback you can provide. Your thoughts and opinions assist us with improving our future presentations, so please don't hold back, and I really do make changes to my presentations based on that, the feedback that I get. So I really do appreciate your honest feedback. All right, so what we're going to talk about today is the new legislation that went into effect in August of last year. We're talking about specifically how it relates to collection delinquency notices and whether or not you're complying with the new legislation. I will tell you as a spoiler, most people are not. So if you are getting pushback from your attorney's office about delinquency notices and whether or not they comply with the statute, you are not alone. We wouldn't have this webinar presentation today if the majority of people were doing it correctly. We are running into a lot of inconsistency and questions and concerns and misunderstandings, miscommunications, et cetera, et cetera. And so I appreciate all of you being here and engaging in this discussion and wanting to get your delinquency notices accurate so that we can all do better moving forward. So really, who cares? Who cares if your delinquency notices are not strictly accurate to the legislation? We all know the legislation changes all the time. We went for a long time after the 1276 updates in around 2014 or so until we had 1137 updates a couple years ago. And that was a really good, nice run where collections were pretty consistent and we didn't have to make any large changes to anybody's processes and procedures and whatnot. And then we got hit again in August of last year, actually in about April or May, and it took effect in August. And we very well may have additional changes coming this year. We really don't know, right? We don't know what will pass. We don't know what the focus will be, but we can certainly feel confident in saying that HOAs do have the legislative focus right now. Of course, they're focused on other things as well, but we are certainly under the spotlight, right? The legislation is concerned about homeowners that have had really unfortunate, difficult circumstances, that have been sent to collections, that have been sent to foreclosure, and they're concerned about fairness. They're concerned about communication and transparency and making sure that everyone is treated fairly. And unfortunately, lost in that a little bit sometimes is the reality that associations need money to function. Right? They need money to be able to provide the amenities and the maintenance responsibilities that they are contractually obligated to uphold and to provide. And so the reality of that is that homeowners need to pay. So we are trying to function within the environment of the legislation, or the legislature has a bit of a magnifying glass on our industry, but we have to keep doing what we're doing because associations and HOAs need the money to be able to provide the services that they have. So hence our presentation today, to make sure that everything is buttoned up accurately on your end before it ever gets to us or whoever your collections attorney is. So something else to keep in mind is the judicial environment that we're working in right now. My experience in this industry since 2008 has been that the judicial environment kind of swings back and forth on a pendulum. And when I entered the industry in 2008, we were in the middle of the recession, and there was a lot of scrutiny on what was being done because people literally could not pay their bills. People were unemployed or underemployed, and the judges wanted to make sure that things were happening exactly to the letter how they should be. And then we came out of the recession and things got a little bit more lax, and there was a lot more deference to associations and their attorneys and confidence that things were being handled correctly. And now we have found ourselves shifted back the other direction because of a lot of different factors. But we are in this environment right now where the judges are back to looking for reasons to rule in favor of a homeowner. And the consequences of that are really high for the association. If the association loses a trial, then they are potentially not going to be able to collect the balance due from the owner. They're not going to be able to get their attorney fees that they have incurred back from the owner. And then they potentially could also have to pay the homeowner's attorney fees on top of that. And so because of the potential here for a lot of monetary penalties and monetary impacts to the association, we want to make sure that things are handled as strictly complying with the law as we can. We want to try to put the association in the best possible position to be able to be successful in collecting money from an owner, regardless of what judge we're in front of, or what mediator we're sitting across from. Whatever the situation is, we want to put you in the best possible position to get a good result. So on top of all of that, there's also in the statute now that if there are foreclosure errors, the association could potentially be fined $25,000 on top of all of that other stuff that I just said. So we certainly want to make sure that we are complying to the letter of the law, making sure that we are crossing all of our T's and dotting all of our I's. Close enough is no longer good enough. We really don't want to move forward on cases that we don't feel strongly have strictly complied with the statute, because we do want to put the associations in the best possible position moving forward. All right, so like I said, the 2024 legislation changed how things happen on your end before the homeowners ever get sent to their attorney for collections. Same if it's a collection agency, it's the same information that applies, collection agency, collection attorney, doesn't matter. The pre-turnover collections process on your end and things that you need to do is the same either way. So we're going to talk about what does the board need to do and what does the management company need to do to work within these laws that are pretty recent. All right. Whoop. Okay. So what does the board need to do? What's the board's responsibility? If they have not yet authorized an update to their collection policy, they need to do that. This has to be compliant with the laws that went into effect in August 2024. So your collection policies from 1137, 2 years ago from 2022, don't comply with the laws that went into effect in 2024. We need to have those collection policies updated before you start doing any kind of delinquency notices or trying to send anybody to collections. We are not permitted to take collection action without that policy being updated first. So we need the boards to authorize the update to the collection policy. We also need boards to understand the new requirements and the limitations of those new requirements. And I understand that it is frustrating. I absolutely understand and I feel their frustration. But that doesn't change what the law says. And it doesn't change that judges are looking for reasons to say that the association didn't do anything correctly. So we need the things that come up most often are the payment plan that the association offers before they ever get to the attorney is for 18 months. And if a homeowner agrees to the payment plan is not void after they miss one payment. It is void after they have missed or been late at least 15 days, 3 times. It can be 3 times over the course of that payment plan. It does not have to be 3 months in a row, but any 3 missed payments will cause them to have that payment plan be void. And at that point, they can be sent to collections immediately. A lot of boards don't like that there is that 3-month delay on top of what they perceive as already an unreasonable delay by having to offer someone an 18-month payment plan. That is a really long time for an owner to not be paying what they owe the association, but that is the limits of the law as they are right now. The other thing that comes up a lot that I find myself explaining or reiterating to boards over and over again is even if your association complied with all of the delinquency notices that were in place under their collection policy that was effective 2 years ago when you first sent them over to collections. Everything was fine then. Everything was done perfectly then. They were sent to collections. Your attorney tried to collect for a while. For whatever reason, they weren't able to collect that balance. And now we're looking at a foreclosure. In that case, the courts look at that foreclosure as a completely separate legal action. And before we can move forward with a foreclosure, the delinquency notices need to be restarted under their current collection policy. So you did everything you were supposed to do under the 2022 policy back in 2022, sent it to the attorney, couldn't get it collected for whatever reason. Maybe they're judgment proof because they're self-employed and don't have a bank account in the state. Maybe the property is owned by a trust or an LLC or something of that nature. For whatever reason, we just couldn't collect from the person. Now the board has had enough and we're looking at possibly foreclosing. You need to restart your collection notice, or I'm sorry, you need to restart your delinquency notices under your 2024 collection policy in order to start a foreclosure. I know that is frustrating. I know it seems stupid. I don't disagree with you. But that is the strict language under which the statute now is written. And again, We are just trying to put the association in the best possible position to be able to collect successfully. What we don't want to do is say, it'll probably be okay, don't worry about it. And then 6 months from now, we have a judge saying, you didn't follow the law correctly. You don't get to collect your attorney fees. You owe them their attorney fees, and you owe them $25,000. That is really what we're trying to avoid. So while that restarting the collection process and delaying things for 60 or 90 days is very frustrating to boards, it really is the best way to try to avoid all of those future problems. All right, so what are the manager responsibilities? We need to get updated policies from your boards, and once those policies are updated, you want to make sure that you have them signed and sent back to the attorney so that they have them on file, so that when you do send over those new collection files, we have everything that we need and we don't have to come back to you and say, this is great, but I need an updated collection policy from you before we can do anything. It just helps streamline the process for us a little bit. All right, and then most important and most frustrating for you all on your end, I'm guessing, is that you had to change your procedures internally. Under the 2022 laws, the payment plan offer letter was sent to the owner by regular mail, by certified mail, by posting at the property, and I believe that there was a few other things that I think I have blocked from my memory at this point. Under the new laws, we no longer have to post at the property. You can post at the property if you want, but it's not going to take the place of one of these other ways that you have to get this letter to the owner. So under the new collection legislation, as of August of last year, that payment plan offer letter needs to go to them by certified mail, and then 2 of the following 3 ways. Call them, you email them, or you text them the letter. You have to do 2 of those. No more posting, no more regular mail. You certainly can send the letter by regular mail, and that's not a bad idea, frankly, because a lot of times if you send something certified mail, it comes back as being rejected or refused by the owner, but the regular mail makes it to them. So it's not a bad idea. It's a great additional safeguard to try to get it to them, but it is not going to take the place of those other requirements to do 2 of the 3 call, email, text. So that is, that I think has caused the most heartburn, at least from my perspective, for management companies with how they have to get that letter to the owners, which opens up a whole different can of questions. And I understand that, and I have slides about that later. So we'll get to some questions about, what does that mean? And what do you have to do? And what happens if we don't have this information, et cetera. But for the purposes of this part right now, your responsibilities are make sure that your internal procedures are updated to comply with the new ways that that letter has to get to the owners. All right, also document everything. You want to document actual communication that you have with the owner, which means if you're emailing them, you want to save copies of those emails to your files. If someone's having a phone call with them, you want to make sure that you have a note in your file as to what was said during that conversation, the exact date and time. Did you try to call them and they didn't answer? You left them a voicemail. Did they call you on what date and time? What was discussed, etc. You also want to document any attempted communication. So if you sent out your letter certified mail like you're supposed to, and it comes back to you as being undeliverable or rejected by the homeowner, or maybe just not ever claimed, picked up by the owner, whatever the case may be, if you get something back saying it didn't get to them, that was an attempt to comply with the law, and so you want to keep that documentation for your files. And then I think the most important advice that I have for you right now is be flexible. It might change again this year. I do not have a crystal ball, and I can't tell you whether or not it's going to change this year. I don't know, but what I can tell you is that it probably won't be like this forever. And at some point, things will change, and we as an industry will need to roll with those changes and go along with them to the best of our abilities. All right, I'm gonna take a look at the chat here real quick. I think a lot of these we are going to, yeah, I think a lot of these we're going to address later. So I'm going to hold off on the questions for now. All right, so what does the 2024 updates to the collection policy mean? What actually needs to be in that policy? Some of this is new for 2022, some of it is new for 2024, but I included them all in here because they are items and requirements that I pretty consistently see being left out of policies that aren't drafted by an attorney. So I want to make sure that you and your boards have all of this information so that their policies can be accurate and maybe dissuade some boards from trying to draft things on their own that maybe won't be compliant. All right, so your collection policy needs to say when assessments are due and when they are delinquent, which means you don't want to have language in there saying they are due at the board's discretion. That's something that was acceptable previously that no longer is going to comply with the law. So the board needs to kind of get nailed down a little bit with when their assessments are due. Are assessments due monthly on the first of the month every month? Are they due quarterly? Are they due semi-annually? And on, are they February 1st and August 1st, or are they January 1st and July 1st? Because I see both of those. You want to be very specific about when the assessments are due. And you also need to say when they're delinquent. That's something that's left out of policies pretty frequently, and it definitely needs to be in there. Most of the time, policies will say they are considered delinquent if not paid by their due date. Some other policies will say they're delinquent if not paid within 10 days of the due date, something along those lines. Either way, it's fine as long as whatever date they choose complies with their governing documents. Sometimes the declarations will specify when assessments are due and when they're delinquent. But for the most part, that's left up to the board discretion, and it can be whatever timeline they want, but it does have to be specifically articulated in their collection policy. We also need to say the amount of late fees, interest rates, and return check fees. For late fees, I often see collection policies that will state that late fees are a percentage of the balance at the time the late fee is incurred, or a percentage of the unpaid assessment at the time that the delinquency is incurred. I advise against that. I think it is smarter and cleaner and wiser, I guess, to have an exact amount of your late fees as long as your governing documents allow for that, as long as your declarations allow for that. It is much better to see a collection policy that says late fees are $15 a month. The reason for that is that interest is capped at 8% by statute. So it is opening up a potential argument for the owner to say that they have interest at 8%. On top of that, they have this late fee that they're calling a late fee, but is actually interest because it is based on a percentage of the balance or a percentage of the unpaid assessment. And so you effectively have an interest rate above 8%. I think that that is a reasonable argument, frankly. I have not seen a whole lot of that happen in practice, but I can absolutely see that potentially being a problem. And so for that reason, I think it is wiser to have your late fees be listed as a dollar amount instead of as a percentage. And with return check fees, there's a cap on those as well. Your return check fees can't be, you can't have a fee over $20 on that one. So that needs to be limited as well. All right, your collection policy also has to say that before being sent to collections, you're going to offer the homeowner a payment plan of at least 18 months. We'll talk about the different sorts of payment plans as well. but it used to be 6 months. In 2022, it changed to 18 months. So we do occasionally see collection policies that still try to say 6 months, or they will say up to 18 months, which doesn't strictly comply either. It is a minimum of 18 months that has to be offered to the owner. If the owner comes back and says, great, I don't need 18 months, I only need 6 months, that's fine. That's no problem. That is at the owner's request. You have complied with your responsibility by offering them the payment plan of at least 18 months, but don't try to skirt that requirement and say, up to 18 months or 12 months or longer at the board's discretion or something like that. You need to actually offer them the 18-month payment plan. Collection policy also needs to list how payments are applied, and then you also want to make sure that your internal accounting systems apply payments in the same way. A lot of times I'll see ledgers that have payments that will break out the amount of the payment and specifically show what amount was applied to unpaid assessments, what amount was applied to unpaid late fees, et cetera, et cetera. You want to make sure that your accounting system reflects the current law and reflects what is in your updated collection policy so that your ledger shows that the payments are being applied as applicable or as the law states as well. The law does state that previously the law said that the collection policy just had to say how payments are applied, and it didn't list a specific order for how payments are to be applied. It said apply them however you want, just say how you're doing it. Well, that changed, and payments have to be applied first to unpaid assessments. Then they can start being applied to other things like late fees, attorney fees, covenant fees, interest, anything along those lines. But they do have to be applied first to unpaid assessments. So make sure that your policies reflect that and also your accounting systems reflect that. Notices also are required to be sent to the owners and to any third party that the owner has requested, and also in any language that the owner has requested. That is something that had a lot of people concerned about how that might work out in practice. I think luckily it hasn't been taken advantage of thus far, although time will tell on that, I suppose. But make sure that when you are getting requests from owners to provide them things in another language or provide copies to a third party, make sure you are complying with that request, because that is something that is explicitly required. All right. And then what do we need to include in that delinquency notice? This is really the meat of what we're talking about here, and the things that we see missing often from the delinquency notices. Again, if you are missing some of this information, do not feel bad. You are not alone. There is a reason why we had a lot of people signed up for this class. It's because it's confusing. The law is unclear in some places. And it is a very common issue that we are seeing, that delinquency notices are not strictly complying with the law. So take the information, apply it to your letters. Don't feel badly about it. We'll just get it fixed and move forward in a better spot. All right, your delinquency notices need to contain the total balance due and a breakdown or an accounting of that balance. That can be anything from listing a little chart that says of that amount, assessments are this much, late fees are this much, covenant enforcement violation fines are this much, etc. That can also be complied with by attaching a ledger to the letter. That I personally think is a more effective way of getting the information to the owner, because a lot of owners want to see that running balance and exactly when this balance started and were my payments applied correctly. And I thought I was brought current here, but you're saying I wasn't because I got this violation fine. I think the ledger just provides more useful information, and it will anticipate and answer a lot of the questions that an owner is going to have if you just provide them a large number that they owe and a breakdown of all of the components of that number without having that ledger showing the running balance of exactly what days this balance came from. But either way complies with the law. Whatever is easier for you is fine with me. You have to tell the owner in your letter whether the balance is comprised of unpaid assessments, unpaid violation fines, or both. This is something that has been a little bit sticky for a lot of management companies trying to automate their systems and be as efficient as you can with getting letters out the door, and I completely understand that. Most associations that I have seen that have met this requirement effectively will have up at the top of their letter, they will have just a line that says this balance is, this is in addition to the breakdown of the balance, right? They'll have a little line at the top that says this balance is comprised of colon, and then there'll be a little box that says unpaid assessments and a little box that says unpaid violation fines. And then there will be a little box, and next to it, it says unpaid assessments and unpaid violation fines. And then you want to check one of those boxes. Don't send out a letter that has all of those things listed and all of the boxes with none of them checked, because then you are not complying with this requirement. I know that is something that is difficult or impossible, frankly, to automate, but it is something that needs to be done in order to comply with the law. You need to offer them the payment plan and give them 30 days to get back to you to either, accept that payment plan or to pay the balance in full. I do see letters relatively frequently that list 10 days or 14 days or 15 days or 20 days or something like that, but you do need to give them 30 days to get back to you. And you need to give them the name and the contact information of the person the owner may contact to verify the debt or enter into a payment plan. And the law specifically says the name and contact information of the person. And so that needs to be a human. I see a lot of letters that say contact ABC HOA management company at this phone number or at this generic email address to verify the debt or enter into a payment plan. And that doesn't strictly comply with the statute. You want to have your manager's name, your account tech's name, whoever it is at your office that would be fielding that call or that email from the owner, put that person's name in there and their contact information in order to comply with that. All right. When you're offering them that 18-month payment plan, there are two options included in the statute. There is one section of the statute that says in order to proceed with collections of a personal judgment against the owner, which is the general collections process that we usually think of. You want to take the person to court, you get a judgment against the person, you try to garnish the person's wages, garnish the person's bank account, things like that, in order to collect the balance due. The other way that we try to collect against people sometimes is through foreclosure. And through foreclosure, you're really collecting against the lien on the property. You're trying to get the property and sell the property in order to satisfy the balance that's due to the association. It doesn't, in the legal realm, the foreclosure is not about the person, it's about the property. And yes, of course, in practice, the person is losing their house, but that is the legal umbrellas that we're working under. We have the collection of the personal assets of the owner versus foreclosure of the lien against the property. And the statute says in order to do personal collections against the owner, you need to offer them a payment plan of 18 equal payments plus current assessments as due. So you take the full balance, you divide it by 18, they pay that amount every month plus their monthly current assessments. It also says if you want to foreclose against someone, you have to offer them a payment plan of at least $25 a month. So that would be $25 a month plus their current monthly assessments for 17 months, with a balloon payment of the total balance remaining due after that on month 18. And the problem with these two different types of payment plans is that usually when you start your delinquency letter process, you don't know, the board doesn't know, I certainly don't know which method of collections is going to be most effective in that particular case. Are we going to be able to collect relatively quickly against the human, or are we not going to be able to for some reason, and we'll need to look at foreclosure down the line? So in order to try to satisfy both of these different kinds of payment plans, we recommend your offer letter has both listed. That way you have covered all of your bases. There's no need to try to figure out on the front end, how is this going to play out? What's going to work better? You have both covered. You're good to go either way, assuming there aren't any additional changes with the legislative requirements down the road. But we can't prevent that. We can't predict that. So working under the information that we have now, the best option is to provide both payment plan options in the letter to the owner. I also, on our sample delinquency payment plan offer letter that we provide, if we do your collection policy for you, the sample letter that we provide also has space for a third option for the homeowner to write in a payment plan that they are proposing. And then it really is up to the board whether or not they want to accept that third option proposed by the owner. But your responsibility is to get those first two offer details in that letter. You have to tell them how much they owe in order to cure the delinquency balance. If they don't want the payment plan, then just send them the balance that's due. And then we have these two bottom bullet points here that have caused a lot of frustration and mental stress, and I don't disagree with it, but it is something that comes up a lot. The statute says that you have to provide covenant enforcement cure language. It doesn't say you have to provide information to them about how to cure their covenant enforcement violations if they have any. It just says you have to do it. So if we are attempting to strictly comply with the statute in order to put the association in the best possible position to be able to collect successfully, we want to include that language in there, even if it is really not applicable to this particular owner's balance because they don't have any covenant enforcement violation fines. I understand that doesn't make any sense from a practical standpoint and a logical standpoint, but it is included in the statute, and it doesn't specifically say if there's fines, then include this. It just says include it. So please include it. The other thing that we get tripped up on a lot is the statute requires small claims court information about how the association or the owner has access to small claims if they want to, deal with certain issues there. That is information that has to be provided. Most of the time, I see letters that have information about small claims court, but the problem that we run into is that it will say the association has the option to proceed with small claims court to try to collect a balance from you. The part that is missing is that we also have to say that the homeowner has access to small claims court as well. So if you want to make sure that the language in your letter says either the HOA or you have this option in order to comply with that requirement. That is something that I see missing relatively frequently. Again, it's small, but we just want to make sure that we have everything buttoned up as well as we can before we head to court and get told that something is wrong. All right. How do we send that payment plan offer letter? We are required to send it certified mail, return receipt requested, and 2 of those 3 ways, email, phone, text. Your responsibility under certified mail is to get that certified mail letter out the door to the owner at the address that you have on file for them, and then that's it. You have no control over whether or not they accept it, whether they reject it, whether they moved and didn't tell you. You don't have any control over what happens to it after it leaves your office. Your responsibility is to get it out the door, certified, return receipt requested, and you're done. You also want to take documentation of that. If you can put down the certified letter tracking number, if you get something back in the mail saying it was undeliverable or it was refused or whatever the case may be, you want to make sure to save that documentation in your file. But you don't have to worry about what happens if they don't get it, what happens if they don't accept it. And then the two of the three, email, phone, text. The law says it has to be to a number or an email that the owner has provided to the association, which opens up a lot of questions. And I'm going to get there in just a second. But I'm saying that's what it says. It says you email, phone call, or text, two of those, to a number or an email the owner has provided to the association. Posting it at the door is no longer required. Regular mail is no longer required. You're not prohibited from doing those things, but they are not required under law. Certainly, if you or your boards decide that you want to keep doing those things, make sure that you keep the documentation of it and you write that somewhere in your file so that we know that that happened. And all that can do is help you later on, but you're not required to do it. But if you do it, make sure you keep the documentation of it. All right, so here's all the questions that we get. What if I don't have their phone number? What if I don't have their email address? I don't know is the answer. I will say any attorney that tells you affirmatively, here's exactly what you do in the circumstance that you have not been given an email or a phone number, I would have serious questions for them, because this statute is very new. It's only been in place now for 5 months. That is a very limited amount of time to have any cases that have gotten in front of judges. And even the cases that have gotten in front of judges, you are going to have a ruling from one judge on one set of facts in one courtroom in one county. That does not at all mean that another judge in that same county in a different courtroom isn't going to think something different, or certainly another judge on the other side of the state isn't going to think something different. Right now, there is a lot of questions about these things that I have listed here. We frankly don't know. We don't know what we're supposed to do in the circumstances where we don't have an email or a phone number. We don't know if we're supposed to read the whole letter to them. We don't know if a link to log in to your homeowner portal is good enough. We don't know. There hasn't been enough time in order to have case law to really figure out what the judges are going to do with this statute, because it's written, it says you have to send the letter two of those three ways, to an email or a phone number the homeowner has provided. It doesn't tell you what to do if the homeowner hasn't provided an email or a phone. It doesn't tell you exactly what to say to them over the phone. It doesn't say exactly what to send them by text. It just says get the letter to them in these ways, or you need to communicate with them in these ways. So I have recommended taking the most conservative approach, because again, trying to put your associations in the best possible position to be able to collect successfully. These are not the easy answers, and these are not the answers that a lot of boards want to hear, but they are the best way to put your boards in the best possible position. So what do we do if we don't have a phone number or an email? What I'm saying is, if you don't have that, then you cannot strictly comply with the statute. You literally cannot provide the information to them at an email or a phone number that they have given you, because they didn't give it to you. And there's no way to force them to give you the information. There's nothing in the law that says homeowners have to provide this, information to their associations. So we are offering a preventative measure to provide a phone and email policy that we're doing with our collection policies, but we can certainly do it separately if someone has gotten their collection policy done by someone else. that says the association may need this information from you down the line at some point, and so please provide us your email or your phone number. The problem is we don't have any teeth behind it. We can't fine them for not providing it. We can't go after them in any way if they don't provide it, because nothing says that they have to give it to us. But the hope is that by soliciting that information now before you need it, you'll have at least more emails and phone numbers for owners if you need it down the road. We're also saying try to find an email and a phone number if you don't have one on file because they gave it to you. A lot of times boards will have access to information. If you all can't find the information, we can do a skip trace to try to locate the information. If we get a phone number, we'll call them up and try to confirm it's them and give that information to you. And we're trying to compile a paper trail that we did everything that we could to try to comply with this law that we are literally unable to comply with if they haven't provided the information. I don't know that it would work. I don't know that a judge would agree that that's close enough is good enough, because it doesn't strictly comply with the statute. But in situations where we literally cannot strictly comply with the statute, we try to do everything that we can to say we tried really hard, judge. The next question that I get from people is, what do I do when they answer the phone? Do I really have to read this entire letter? I don't know, maybe. I think the safest option is to start reading the letter until they tell you to shut up or stop. But I know that some associations, management companies are not doing that. The further away that you stray from verbatim sending that letter to the owner in these various ways, the more doorways you're opening for judges to say you haven't complied, and then you get all of the financial hits for doing that. And so my recommendation is that, yeah, start reading the letter. It's weird, it's uncomfortable, it's awkward, but it's the best way that we can make sure that we're complying with this statute. Can I attach the letter as a PDF or a picture to the text? I think that's fine. That's good news, right? I think that's fine. I think you are literally getting that letter to that person through a text message. But again, I think any step that you come away from that, sending the language of the letter or the PDF or a picture of the letter to a text, you're opening doors. So if you say, here's a link to important information, that's probably one more step away from the body of the email or the body of the letter in the text. Even more so than that, I have seen texts that say, hey, this is your association reaching out. We have important information for you. Please log on to your portal. That worries me a little bit more, because that's an extra step away from sending the actual letter via the text. And so really, you want to try to strictly comply to the best of your ability. When you can't, we try to do everything we can to show that we have. But I will tell you, some judges will absolutely say, of course you can't strictly comply with this. They didn't give you the information. You have no authority to demand they give you the information. What else are you supposed to do? You tried to find an email. You couldn't find an email. Well, I suppose if you can't find an email, you can call or text. But if you can't find a phone number, what on earth are you supposed to do? You did good enough. Great. But there are judges that will take the opportunity to rule against an association for not strictly complying. So do the best that you can. And I think it's important to have a conversation with your boards if you are not strictly complying, that there are some potential, there's liability out there. All right. We're almost done. When you're referring a delinquent account to the attorney or to the collection agency, the board has to go into executive session and vote on sending the account to collections. I don't believe that that can be done by email. I think you are, again, opening a door to potential to potentially not having complied with the statute if you try to do it by email. So my recommendation and my advice is to do it at a board meeting in executive session. And then you want to document that vote by either a signed resolution or meeting minutes. If you do it in meeting minutes, make sure that you don't list anything on the minutes that identify that owner. You don't want to say Kiki Dilly at 123 Main Street got sent to collections. If you could identify it with like an account number or something like that, that's great. Just some way that we can connect the file that has been sent to us to the minutes showing that there was a vote on that particular account. All right. In 2024, the requirements to be able to foreclose got turned on their heads a little bit. We now have to have a personal judgment against the owner, which, if you recall, I was talking several minutes ago about how we have two ways of trying to collect against someone. Having a personal judgment against them is doing that normal standard collections route that we talked about. We serve the person, we have a lawsuit against the person, we get judgment against the person, and we try to collect against them. That is pretty standard, frankly, that we will try to go after the owner personally before we resort to taking a foreclosure action against them. Foreclosure is more extreme, it's more expensive, it's more time consuming, and most of the time we don't just jump to foreclosure unless there's a really compelling reason for that. So that part in practice didn't really affect our practice or our recommendations to boards. So first, we do, though, have to have either the personal judgment against the owner, or we have to have attempted to serve them for 180 days, which makes it still possible to foreclose against those people that maybe we can't find them. Maybe they're living overseas and getting them served is a nightmare. There's other ways that we can address those issues. If we are not able to get them served in 6 months, then we can move to foreclosure at that point. Again, in practice, that doesn't really change anything on our end because we're usually trying to do everything we can do before we ever recommend a foreclosure to someone. The exceptions to this requirement is if the homeowner is deceased or has filed bankruptcy, that makes it impossible or extremely difficult to serve them. And so that carves out that exception. If it's not the owner's primary residence, then that is an exception. And if the owner is not a human, so if the owner is a trust or an estate of a deceased person or an LLC or anything along those lines, or the bank, if the bank is foreclosed and the bank is the owner, then in those circumstances, we don't have to first get a personal judgment or attempt to serve them. So that's nice to have those exceptions explicit in the law. As I said before, before we can actually move to foreclosure, if the law has changed since they first got sent to collections and we are now looking at foreclosure, we will send it back to you to restart the delinquency notice process under the updated collection policy. And I have board/manager because that's something that you all have to do in order to comply with this, although it would be done at our recommendation. Usually you would get an email from me or one of the other attorneys with the office saying, hey, we've tried to collect on this and we're not able to for the following reasons. We think at this point it might be good to look at a foreclosure. Our foreclosure attorney has done a very preliminary look at it, and she agrees that this may be a good option for foreclosure. In order to move down that road, we need you to restart your delinquency notices under the updated policy. Let us know when, either if you hear from them, which is great, then you get paid, or if you don't, let us know when your last letter under your delinquency notice process has expired. And at that point, we'll move ahead with making a formal recommendation for foreclosure, sending you all the documents and information to get with your board and get in front of your board if you want to talk with them about the foreclosure process. We are now required to offer mediation to an owner 30 days before filing the foreclosure. That's something that we do on our end. It certainly turns things on its head a little bit because almost every single time that we file a lawsuit against an owner to collect, the court is ordering us to go to mediation anyway. So the fact of going to mediation isn't particularly upsetting or different. It's just that it has to be offered at the beginning before we file the lawsuit, as opposed to when it would normally take place during the collections process and during the foreclosure process. I don't know if if judges will look at this as a replacement for mandatory mediation during the foreclosure process as well. I suspect it'll probably depend on whether or not the homeowner actually accepted the offer and went through mediation. If you've already mediated once, I think it's possible that a judge might say there's no need to do it again later. But my guess is that most owners will not take us up on that offer of mediation, and you'll just be doing it later on anyway. We also have to notify other lien holders 30 days before the filing that we are going to be filing a lawsuit, which they get notified of it when we file it anyway. We have to serve all of the other lien holders. So this really just notifies them earlier as opposed to when it was happening before. They'll get it again when we draft the lawsuit, file it, and send it out for service. I think that this could potentially work in the association's favor because a lot of times if there is a second mortgage or a large enough junior lien holder that has an interest in the property, a lot of times they will pop up whenever they get served with the foreclosure lawsuit and will say, I will pay this balance that's due to the association in order to stop your foreclosure. It protects my lien against the property, and I will just add it to the balance that is due on my lien, and that way you all get paid, which is great. The homeowner saves their home, and the balance on the second mortgage or whatever it is increases, so they get paid when the homeowner sells the property down the road. I suspect that this might just speed up that process a little bit, and we will find ourselves getting payment from other lien holders earlier rather than having to actually go through the foreclosure process to get there. But again, it's conjecture because these laws are new and they're so new that there hasn't been a whole lot actually getting to the points where these things are happening. All right, and then one last bonus for you all. I'm done talking about delinquency notices and collection policies and what have you. And I just wanted to point out a bankruptcy trend that we're seeing because I think it's an important thing to get in front of you all as managers and account techs so that you are aware of this. If a homeowner files a bankruptcy and you receive anything at all that looks like any kind of a bankruptcy document, make sure you notify the homeowners, or the association's attorney. You want to get those bankruptcy documents in front of them as quickly as possible. We certainly on our end do periodic bankruptcy searches for people that we have open files for in our office at different points in our process, just as a check to make sure that we are not doing something that would potentially violate the bankruptcy stay at that particular point. But a lot of times you get notified before we do. Sometimes we don't get notified at all. And if we are in between one of those checkpoints that we aren't checking on our end, if you all find out, that's the same thing as me finding out from a legal standpoint. So you want to make sure that you get that to us right away. Similarly, if you receive those documents regarding any homeowner who is not in collections yet, even if they haven't made it all the way through their delinquency notice process, still get it to the attorney right away. The deadlines in the bankruptcy filings don't care that it was sent to you versus me, or they don't care that the person hadn't quite gotten all the way through the delinquency notice process. Those deadlines are still going to be what they are, and if we miss them, a lot of times we're out of luck. So one of the things that you want to confirm with your attorney is, should we stop sending delinquency notices to this person? And the answer is probably yes, but you'll still want to send the monthly invoices that are required to go out to all homeowners with a balance. But there is some language that I recommend that you include on there that specifically says, this is not an attempt to collect this debt. This is for informational purposes only if you're in bankruptcy. And that way we've complied with the requirement to send monthly notices to the owner, but we're also not violating the bankruptcy stay. We're trying to walk that line between those two things. Also, we recommend not recording a lien against the property after you've become aware of the bankruptcy, because that could potentially be a violation of the stay as well. And the trend here is that bankruptcy attorneys are getting very aggressive about violations of the automatic stay. We had one several years ago where a bankruptcy attorney was requesting $10,000 as a payment to the owner for sending one letter after bankruptcy had been filed. Now, they did not get $10,000, but the point is he thought that that was a reasonable amount that a judge wouldn't just throw him out of court for. So we want to make sure that you all are aware of the need to get the attorney involved right away if you get a bankruptcy notice on a homeowner. All right, I have managed to talk for an hour and 51 seconds. So I'm not going to go through the chat and answer questions, and I apologize for that. Hopefully I answered a lot of them as I was going, because I did see some at the beginning that were about details and issues that I did address directly later. But in the event that I did not answer your question, there's my email address. Please feel free to reach out to me. I'm happy to provide any information that you need, any blurbs that you need about, including on the bottom of monthly delinquency notices. If you have somebody in bankruptcy, I send that language out all the time. Happy to send that to you if you want it, or if you need anything else, have any questions, concerns, etc. There's my email address. Feel free to reach out with anything that you need. I hope everybody has a great day, and thank you for attending. We'll see you later.